It must be noted that a motion for dismissal of a cabinet secretary is a special motion under Standing Order 61 which ought to be disposed of expeditiously. Consequently, the clerk is required to consider the proposed motion and advise the Speaker without unnecessary delay. Further, in the case of the Speaker, Standing Order 64 and 66 provide that a proposed motion shall be disposed by the Speaker within 3 days of receipt of notice by a member. The 3 members at the bar, take your seats. This will take a little longer. Take the nearest seats. Thank you. Honorable members, the strict timeline of 3 days is intended to allow the Speaker to examine the proposed motion and any evidence attached to it and determine whether the proposed motion meets the procedural requirements outlined in the standing orders. In this regard, I note that the member for Bumola constituency submitted the proposed motion to my office last week on Wednesday, 24th April 2024. Article 259(5) of the Constitution provides for the manner of computation of time. It guides that where time is expressed as days, the day on which the first event occurs is to be excluded, and the day by which the last event may occur is to be included when computing time. Consequently, the period of 3 days that applies to the Speaker in respect of the proposed motion started running from Thursday, 25th April 2024, the 3 days expiring on Saturday, 27th April 2024, and as such, the earliest available opportunity for the Speaker to notify the House on the admissibility of the proposed special motion is today, being the nearest available sitting of the House since receipt of the proposed motion. Honorable members, allow me to highlight the legal and procedural requirements that guide the process of dismissing a cabinet secretary. Article 152(6) of the Constitution provides, and I quote, "A member of the National Assembly, supported by at least 1/4 of all the members of the Assembly, may propose a motion requiring the President to dismiss a cabinet secretary. A, on the grounds of gross violation of a provision of the Constitution or any law, or any other law, and B, where there are serious reasons for believing that the Cabinet Secretary has committed a crime under national or international law, or C, for gross misconduct." Procedurally, Standing Order 661 provides that before giving notice of motion under Article 152(6) of the Constitution, a member shall deliver to the clerk a copy of the proposed motion in writing. A, stating the grounds and particulars in terms of Article 152(6) of the Constitution upon which the proposed motion is made. B, signed by the member, and C, signed in support by at least 1/4 of all the members of the Assembly. Honorable members, additionally, the Standing Order 64(1)A provides as follows on the admissibility of grounds for removal from office. 1A, the grounds specified in a motion under this standing order shall be admissible if A, framed clearly to particularize and disclose a gross violation of the Constitution or other written law, where gross violation of the Constitution or other written law is indicated as a ground for the intended removal. B, stating with precision the provisions of the Constitution or other written law that are alleged to have been grossly violated, where gross violation of the Constitution or other written law is indicated as a ground for the intended removal. And C, accompanied by necessary evidence, including annexures or sworn testimonies in respect of the allegations. Honorable members, it's worth noting that Standing Order 64(1)A and 66, as presently couched, find their basis from the practice of the House in the 11th and 12th Parliament, where notices of motion were submitted by members for dismissal of various cabinet secretaries. This includes the notice of motion for dismissal of the then cabinet secretary for devolution, Honorable Anne Waiguru, the notice of motion for dismissal of the then Cabinet Secretary for Transport, Mr. James Macharia, and the notice of motion for the dismissal of the then Cabinet Secretary for Education, Professor Jacob Kaimenyi. My predecessor, the Honorable Justin Muturi, Speaker, has had occasion to guide the House on the manner of considering a special motion such as the one proposed by the Honorable Member for Bumula. In a communication issued on 22nd October 2015 on the processing of special motions on removal of state officers, the Speaker guided as follows. Members at the bar, take the nearest seat. The nearest seat. Take the nearest seat to the lady member. Member for Garissa. The Speaker guided the House as follows: that all special motions brought before the House under Article 152(6) of the Constitution should comply with the threshold established by the courts of law as to what constitutes gross violation of the Constitution or gross misconduct under the Constitution. That the question of determining what constitutes gross violation of the Constitution or gross misconduct is one that clings and hangs on the impeachable authority of the House and is exercisable in two instances. Firstly, at the point of the approval of the special motion for impeachment or dismissal by the Speaker pursuant to the Standing Order 47(3)(b) and (e), which requires the Speaker to be satisfied of the constitutional and evidential propriety of the special motions. Secondly, at the point of investigations conducted by the relevant select committee or tribunal pursuant to the provisions of the relevant article of the Constitution. Averments made in the special motions should be accompanied by the necessary evidence, including annexures and sworn testimonies in respect of the allegation as may be necessary. Honorable members, our courts have also grappled with the question of the threshold for admissibility of impeachment motions. This has led them to set a standard for determining what constitutes gross violation of the law, gross misconduct in impeachment process through a number of precedent-setting cases. Notably, the High Court of Kenya in Martin Nyaga Wambora and 30 others versus the County Assembly of Embu and 4 others, Embu Constitutional Petition number 7 and 8 of 2014, consider the issue of the required threshold for determining what amounts to a gross violation of the Constitution and gross misconduct in impeachment processes. With regard to what constitutes gross violation of the Constitution, the court observed that, and I quote, "The charges framed against the governor and the particulars thereof must disclose a gross violation of the Constitution and any other written law, and the charges as framed must state with degree of precision the articles or even sub-articles of the Constitution or the provisions of any other written law that have been alleged to be grossly violated." Honorable members, the court further gave examples of constitutional provisions whose violation would constitute gross violation of the Constitution. According to the court, this includes the 3 members at the bar. Take the nearest seats. Take the nearest seats. Thank you. According to the court, this includes Chapter 1 on the sovereignty of the people and supremacy of the Constitution, more specifically Articles 1, 2, and 3(2) of the Constitution. Chapter 2, Article 4, that establishes Kenya as a sovereign multi-party republic, and Article 6 that establishes devolution and access to services. Article 10 on the national values and principles of good governance. Chapter 4 on the Bill of Rights. Chapter 6, Articles 73 and 78 on leadership and integrity. Chapter 12, Article 201 on principles of public finance. Chapter 13, Article 232 on values and principles of public service. and Chapter 14, Article 238 on principles of national security, among other constitutional provisions. Further, in respect of what constitutes gross misconduct, the court observed that whether a conduct is gross or not will depend on the matter as exposed by the facts. It cannot be determined in a vacuum, but in relation to the facts of the case and the law policing the facts. Gross misconduct is defined as a grave violation or breach of the provisions of the Constitution and a misconduct of such a nature as amounts, in the opinion of the House of Assembly, to gross misconduct. Honorable members, drawing from the foregoing, the House amended its standing orders at the end of the 11th Parliament to comply with the prescribed thresholds. Presently, our standing orders 64 and 66 incorporate the pronouncements of the court on the threshold for admissibility of grounds for removal of a cabinet secretary by requiring that grounds in a motion must be framed clearly to particularize and disclose a gross violation of the Constitution or other written law. And such grounds must also state with precision the provisions of the Constitution or other written law that are alleged to have been grossly violated. Honorable members, having examined the legal and procedural requirements of processing special motions for the removal of persons from office, permit me now to determine whether the proposed special motion by the member for Bumula is admissible. Honorable members, it is worth noting that the Standing Order 47(3)(b) and (e) places an obligation on the Honorable Speaker to make a determination on whether any proposed motion is contrary to the Constitution or contains allegations which the mover cannot substantiate. As noted earlier, the question of determining what constitutes gross violation of the Constitution or gross misconduct is one that clings and hangs on the impeachable authority of the House and is exercisable in two instances. Firstly, at the point of the approval of the special motion for impeachment by the Speaker, and secondly, at the point of investigations conducted by the relevant select committee. Honorable members, in determining the admissibility of the motion proposed by the member, I am required to examine two key issues. The first issue is whether the proposed motion meets the requirements of the Constitution and standing orders as to form the threshold required to move such a motion. And the second issue is whether the grounds as contained in the proposed motion are admissible. Honorable members, on the first issue, I note that from a reading of Article 152(6) of the Constitution and Standing Order 66, a proposed motion by a member for the dismissal of a cabinet secretary must be supported by at least 1/4 of all members of the Assembly. 1/4 of all the members of this Assembly is 87.25. In particular, in parliamentary practice, a decimal point is rounded off to a whole number. Consequently, the threshold for initiating a motion for the dismissal of a cabinet secretary is 88 members of this House. Secondly, the Standing Order 66 provides that the proposed motion should be in writing. The proposed motion should state the grounds and particulars in terms of Article 152(6) of the Constitution upon which the proposed motion is made. The proposed motion should be signed by the member and accompanied by the member and signed in support by at least 1/4 of all the members of the Assembly. Honorable members, looking at the proposed motion by the member, I note that pursuant to Article 152(6) of the Constitution and Standing Order 66, the member has stated the grounds and given the particulars upon which he proposes the dismissal of the Cabinet Secretary. Additionally, pursuant to Standing Order 66, the proposed motion is also in writing and signed by the Honorable Member. Further, under Order 152(6) of the Constitution and Standing Order 66, the Honorable Member has attached a list of the signatures of 110 members of the National Assembly who have signed the motion in support. Members at the bar, take the nearest seats. Take the nearest seats. Jalango, take the nearest seats. Honorable members, consequently, I find that the proposed motion by the member for Bumula meets the requirements of Article 152 of the Constitution and Standing Order 66 as to form and the threshold required for a member to move a motion for dismissal of a cabinet secretary. This settles the first issue. Honorable members, moving to the second issue on the admissibility of the grounds specified in the motion, under Standing Order 64(1)A and 66, grounds cited in the special motion are admissible if A, framed clearly to particularize and disclose a gross violation of the Constitution or other written law, where gross violation of the Constitution or other written law is indicated as a ground for intended dismissal. B, they state with precision the provisions of the Constitution or any other written law that are alleged to have been grossly violated, where gross violation of the Constitution or other written law is indicated as a ground for the intended removal. And C, accompanied by necessary evidence, including annexures or sworn testimonies in respect of the allegations. Honorable members, Article 152(6) of the Constitution provides for 3 grounds for which a cabinet secretary may be removed from office. These are gross violation of the Constitution or any other law, serious reasons to believe that the cabinet secretary has committed a crime under national law, and gross misconduct. Permit me now to highlight the grounds specified in the motion for dismissal of the cabinet secretary for agriculture and livestock development. Honorable members, on the ground of gross violation of the Constitution, the member for Mula has stated as follows in the proposed motion: A, that the cabinet secretary has grossly violated the Constitution, in particular Article 2 and 10(1)(c) of the Constitution, on national values and good governance, for failure to undertake public participation with the relevant stakeholders in the implementation of a far-reaching policy decision on the procurement and distribution of fertilizer. That the conduct of the cabinet secretary of approving procurement and distribution of fake fertilizer by the NCPB discloses a gross violation of national values and principles of good governance contrary to Article 10(1)(b) of the Constitution. C, that the conduct of the cabinet secretary of approving the procurement and distribution of fake fertilizer discloses a gross violation of the Constitution by infringing Article 46 of the Constitution of Consumer Rights to goods and services of reasonable quality and their protection of health, safety, and economic interests. D, that the conduct of the cabinet secretary of approving the procurement and distribution of fake fertilizer amounts to gross violation of the public trust, and the cabinet secretary failed to demonstrate respect for the people, bring honor to the nation and dignity to the office, and promote public confidence and integrity of the office contrary to Article 73(1) of the Constitution. E, that the conduct of the cabinet secretary of approving the procurement and distribution of fake fertilizer amounts to gross violation of the principles of public finance contrary to Article 201 of the Constitution, as public money was not applied in a prudent and responsible way. F, that the conduct of the cabinet secretary in which he submitted to the Departmental Committee on Agriculture that the NCPB signed an agent's agreement with 51 Capital Africa Diatomite Industries for supply and distribution of GPC diatomaceous for its commercial function, and that the product was not sold as a chemical fertilizer but as soil conditioner, was in gross violation of Article 152(5)(a) and E 6, 7, 8, 9, and 10 of the Constitution. That the conduct of the cabinet secretary of overseeing the implementation of the budgets of the NCPB under his control for the procurement and distribution of fake fertilizer is a gross violation of values and principles of public service on use of resources efficiently, effectively, and economically. Honorable members, the proposed motion also seeks the dismissal of the Cabinet Secretary for Agriculture on the ground of serious reasons for believing that he has committed a crime under the national law. To this end, the member for Bumula constituency has stated as follows in the proposed motion: that the conduct of the Cabinet Secretary discloses grounds that there are serious reasons for believing that the Cabinet Secretary has committed a crime under the national law involving offences relating to abuse of office and false claims contrary to Section 100 and 101 of the Penal Code. B, that the conduct of the Cabinet Secretary discloses grounds that there are serious reasons for believing that the Cabinet Secretary has committed a crime under national law relating to forgery, uttering false documents, and procuring execution of documents by false pretenses contrary to Section 353 and 355 of the Penal Code. The member further avers that the Cabinet Secretary is currently under investigation by the DCI following the findings of the court in FML versus DPP and 3 others, Registrar of Companies and 10 others, 2021 Kenya law reports, and is further facing arrest and prosecution in 6 pending civil and commercial and family suits. Honorable members, finally, on the third ground, the member for Bumula constituency seeks the dismissal of the Cabinet Secretary for Agriculture and Livestock Development on the grounds of gross misconduct, and states as follows: A, that the conduct of the Cabinet Secretary of getting into public spats with journalists who unearthed the distribution of the fake fertilizer discloses the ground of gross misconduct insofar as a state officer he has failed to demonstrate professionalism in carrying out duties of the office and in a manner that maintains public confidence in the integrity of the office contrary to Section 11A of the Leadership and Integrity Act, Cap 185C. B, that the conduct of the Cabinet Secretary of storming into the manufacturing plants and purporting to be revoking licenses without conducting investigations amounts to gross misconduct insofar as a state officer he has failed to demonstrate professionalism in carrying out duties of the office and in a manner that maintains public confidence in the integrity of the office, manner contrary to Section 11A of the Leadership and Integrity Act, Cap 185C. That the conduct of the Cabinet Secretary of approving procurement and distribution of fake fertilizer insofar as a state officer he has failed to exercise public trust in the best interest of the people of Kenya amounts to gross misconduct contrary to Section 8 of the Leadership and Integrity Act, Cap 185C. And D, that the conduct of the Cabinet Secretary of approving procurement and distribution of fake fertilizer insofar as a state officer he has failed to exercise his duties to the best of his ability and to carry out the duties efficiently and honestly and in a transparent and accountable manner and amounts to gross misconduct contrary to Section 10A and B of the Leadership and Integrity Act 185. E, that the conduct of the Cabinet Secretary of approving the procurement and distribution of fake fertilizer by NCPB discloses the ground of gross misconduct insofar as the state officer has failed to demonstrate professionalism in carrying out duties of the office in a manner that maintains public confidence in the integrity of the office contrary to Section 11A of the Leadership and Integrity Act, Cap 185C. F, that the conduct of the Cabinet Secretary of approving the procurement and distribution of fake fertilizer by NCPB and misleading the public by giving false information to the Departmental Committee on Agriculture that GPC diatomaceous was distributed as soil conditioner and not fertilizer amounts to gross misconduct contrary to Section 29 of the Leadership and Integrity Act, Cap 185. Members at the bar, take the nearest seats. Take the nearest seats. Thank you. Honourable members, in addition to the three grounds that I have just highlighted, the member for Bumula has attached additional background information to further substantiate his stated grounds. Additionally, the honourable member has attached a sworn statement in which he avers that all the information stated in the proposed motion is true and correct to the best of his knowledge. Notably, the honourable member has also annexed to the proposed motion evidence and supporting documents contained in 5 annexes. This includes the response by the Cabinet Secretary to the Departmental Committee on Agriculture and Livestock correspondences, statements, a court judgment, Honorable FML versus DPP and 3 others, Registrar of Companies and 10 others, 2021 e-Kenya law reports and submissions by the Kenya Bureau of Standards, KEBS, the Departmental Committee on Agriculture and coal logs, among other documents. Honourable members, in light of the foregoing and pursuant to Standing Orders 64 and 66, I'm of the considered opinion that the grounds specified for the dismissal of the Cabinet Secretary for Agriculture and Livestock Development as contained in the proposed motion A are framed clearly to particularize and disclose a gross violation of the Constitution and other written law, in this case being the Penal Code and Leadership and Integrity Act. B, state with precision the provisions of the Constitution or other written law, in this case the Penal Code and the Leadership and Integrity Act, that are alleged to have been grossly violated, and C, are accompanied by necessary evidence, including annexed sworn testimonies in respect of the allegations. Consequently, the grounds for dismissal of the Cabinet Secretary for Agriculture and Livestock Development and contained in the proposed motion comply with the requirements of Standing Order 64, 1A and 66. This also settles the second issue. Honourable members, in view of the foregoing, I find that the proposed special motion meets the applicable procedural requirements for it to be admitted to the next stage. Order. Order. You can cheer after I finish my ruling. Those foot thumpings are an interruption. In this regard, honourable members, as with a light touch, I note that Standing Order 47 4A provides that a member shall give notice of motion in the House within 3 sitting days following approval by the Speaker. In the circumstances following my approval of the proposed motion, I will allow the member for Bumula to give the notice of motion for dismissal of the Cabinet Secretary for Agriculture and Livestock Development this afternoon under Order number 6 on notices of motion. Once the honourable member gives the notice of the motion under Standing Order 47 4A, the motion shall proceed to the next stage. Honourable members, I will now highlight a summary of what is expected of the House once the member gives the notice of the motion. In terms of timeline, pursuant to Standing Order 64 and 66, the House is required to dispose of the motion within 7 days of the member giving notice, under Standing Order 47. In the event the House does not adhere to the timeline, the motion shall be deemed to have been withdrawn and shall not be moved again in the same session except with the leave of the Speaker. Consequently, if the member for Bumula gives notice this afternoon, the House has until next week, Tuesday, 7th May 2024, to dispose of the motion. However, noting the House is scheduled to proceed on a 1-month recess from Friday, 3rd May 2024, it is advisable that the House disposes of this motion by Thursday, 2nd May 2024. This shall allow the House to become seized of the matter before proceeding on recess. Honourable members, under Article 152(7) of the Constitution, the House becomes properly seized of the matter if the motion is supported by 1/3 of the members of the National Assembly. Upon approval of the motion, the House is required to appoint a select committee of 11 members to investigate the matter. A third of all the members of the National Assembly, which is 116.3, rounded off to a whole member, the motion shall require the support of 117 members for it to be referred to a select committee for investigations. With regard to the timelines applicable to the committee, Standing Order 66.5 provides that the select committee shall, within 10 days, report to the Assembly whether it finds the allegations against the Cabinet Secretary to be substantiated or otherwise. If the select committee reports finds that the allegations are unsubstantiated, no further proceedings are taken thereafter. However, if the select committee report finds that the allegations are substantiated, the House is required to afford the Cabinet Secretary an opportunity to be heard and a vote whether to approve the resolution requiring dismissal of the Cabinet Secretary. Pursuant to Article 152.10 of the Constitution, a resolution requiring the President to dismiss a Cabinet Secretary must be supported by a majority of the members of the National Assembly, which is 175 members. A resolution that achieves the required support must be promptly delivered to the President and is bound to dismiss the Cabinet Secretary in question upon receipt. Honorable members, from the foregoing, you will agree with me that once the member for Bumula gives the notice of motion this afternoon, the stage shall be set for the House to commence the consideration of the motion. To this end, members should take cognizance of the constitutional and procedural requirements, the threshold and prescribed timelines at different stages of consideration of the motion that I have just highlighted to you. Honorable members, in summary, therefore, I wish to guide the House as follows. Members at the bar, take the nearest seats. Take the nearest seats. Honorable members, I now wish to guide the House as follows. One, that the proposed motion by the member for Bumula constituency meets the applicable procedural requirements of Standing Order 64 and 66 for it to be admitted and considered by the House. Two, that consequently upon the reading of Order number 6 this afternoon, I will permit the member to give notice of motion for the dismissal of the Cabinet Secretary for Agriculture and Livestock Development in accordance with the requirements of Standing Order 47.4a. Three, that since today is not a day for debate, in giving notice of the special motion, the member shall limit himself to a summary of its content, state the grounds upon which the special motion has been made, and the names of the members who have appended their signatures in support of the special motion as required under Article 152 of the Constitution and Standing Order 66. That the clerk is hereby directed to publish the special motion for the dismissal of the Cabinet Secretary for Agriculture and Livestock Department in the order paper for Thursday, 2nd May 2024, in the manner contemplated under Standing Order 66.3, for consideration by the House during the morning sitting of that day, which has been agreed upon by the House Business Committee. The House is accordingly guided. I thank you. Go to Order number 6.
Order number 6, notices of motion.
Member for Bumula.
Thank you. Thank you, Honorable Speaker. Pursuant to the provisions of Article 152(6) of the Constitution and Standing Order 64(1)A and 66, I beg to give notice of the following special motion for removal of Honorable Franklin Mithika Linturi, EGH, Cabinet Secretary for Agriculture and Livestock Development on the following grounds. 1. Gross violation of provisions of the Constitution or any other law. 2. That there are serious reasons believing that the Cabinet Secretary has committed a crime under national law. 3. Gross misconduct. This is in relation to the approval of the procurement and distribution of fake fertilizer by the National Cereals and Produce Board and submitting false information to a committee of the National Assembly on the distribution of GPC diatomaceous, which was distributed as a soil conditioner and not as fertilizer.
Order. Order, honorable members. Order. Order, honorable members. Order. Order, honorable members. Order.
For the interest of farmers.
Order, honorable members. It is out of order to be on your feet when the speaker is on his feet. The House is still in session. Those members who want to have conversations, there's a lobby out there, there's a coffee shop out there, and there are rooms for the speaker which allow you to go and converse behind here. Let's give the House some reasonable silence to hear each other.
Honorable Speaker, do I start?
Yes, no, continue.
This is in relation to the approval of the procurement and distribution of fake fertilizer by the National Cereals and Produce Board and submitting false information to a committee of the National Assembly on the distribution of GPC diatomaceous, which was distributed as a soil conditioner and not a fertilizer. I have particularized each of the grounds and attached evidence to substantiate each claim. Now, therefore, in accordance with Article 152(6) of the Constitution, this House resolves to recommend to the President to dismiss the Honorable Franklin Mithika Linturi from the position of Cabinet Secretary for gross violation of Article 10, 46, 75, and 201 of the Constitution, the Leadership and Integrity Act 2012, and the Public Ethics Act 203, and for gross misconduct. Honorable Speaker, pursuant to Standing Order 66, the following members who constitute at least a quarter of the membership of the House have appended their signatures in support of the notice of motion. I will read. 1. The Honorable Wanami Wamboka, the Honorables Joyce Kamene, Raphael Sauti Bita Wanjala, Fatuma Zainab Mohamed, Paul Musimi Nzengu, James Wambura Nyikal, Gideon Mutemi Mulyungi, Julius Musili Mawadhe, Rebecca Nonaishi Tongei, Pauline Lenguris, Yusuf Mohamed Farah, Dick Maungu Oyugi, Irene Nyakerario Mayaka, Anton Tomo Lodge, Marianne Jebet Kitani, Beatrice Kahai Adagala, Adams Kipsaina Korir, Parashina Samuel Sakimba, Anthony Kibagendi, Martin Peters Owino, Catherine Nanjala Wambilianga, Joseph Maero Oyula, Stephen Mogaka, Doris Donya Aburi, Beatrice Kadeveresia Elachi, Shakil Ahmed Shabir Ahmed, Clive Ombane Gisairo, John Walter Owino, Thaddeus Kidhuan Zambia, Elsie Busihile Muhanda, Frederick Lusuli Ikana, Daniel Ogoka Manduku, Mohamed Aden Ado, Patrick Simiyu Baraza, Zamzam Mohamed Chimba, David Losiako Kosin, Daniel Wanyama Sitati, Gadhoni wa Mchomba, Mohamed Saud Machele, Samuel Onunga Atandi, Charles Ngusia Nguna, Mwago Amos Maina, James Opio Wandai, Junet Sheikh Nur Mohamed, Obadia Barongo Nolfason, Gertrude Mbeyu Mwanyanje, Geoffrey Makoha Odanga, Hamisi Chome Abdi, Erastus Kivasu Nzioka, Sarah Polata Korere, Kajwang Tom Joseph Francis, Makali Benson Mulu, Guyo Wako Jaldesa, Paul Kahindi Katana, Joshua Aduma Owor, Joshua Oduma Owor, John Mbadi Ngongo, Mishi Juma Hamisi Mboko, Hussein Abdi Bare, Innocent Obiri Momanyi, Millie Grace Akoth Odhiambo, Irene Mudhoni Kasalu, Patrick Kibagendi Osero, Jerusha Momanyi Mongina, Joshua Odongo Oron, Abubakar Ahmed Taib, Florence Jematia Segon, John Okwisia Makali, Mangale Munga Chifromondo, Geoffrey Ekesa Mulanya, Timothy Kipchumba Torotich, Ekomas Mwengi Mutuse, Gideon Kimao Kipkoech, Victor Kipngetich Koech, Catherine Nahabi Omanyo, Jepto Ngelechei Caroline, Stephen Mule, Lona Sankare, Peter Nabulindo, Mumina Bonaya, David Mboni, Jane Koyo, Charles Owere, Rashid Juma, Bashir Abdullahi, Abdi Ali, Tungule Kazungu, Ngozi Rai, Hari Kombe, Honorable Timothy Wanyonyi, Haika Mizigi, Fatuma Wajia, Kakuta Maimai, Nabwera Nabii, Innocent Mugabe, Christine Ombaka, Kitilai Olentutu, Joshua Malio, Gidhua wa Mashukuru, Mark Mwenje, Geoffrey Ruku, Mary Emase, Eve Obara, Otiende Amolo, Senior Counsel, Peter Orero, Babu Owino, Dr. Joyce Osogo, Amina Mnyazi, Adipo Okwome, J.M. Naika, and Honorable Speaker received even more. Thank you, Honorable Speaker. And lastly, Honorable Speaker, I'd forgotten Omoher Harun. Thank you, Honorable Speaker.
Yes, Honorable Wandai.
Thank you very much, the Honorable Speaker. Honorable Speaker, let me say that this afternoon I stand before this House a very happy man. Honorable Speaker, today you have made history. I want the Speaker to listen to me. Honorable Speaker, I'm saying that today you have made history and you have put this House on the pedestal of a transformative institution, an institution that adheres to the rule of law and constitutionalism. Honorable Speaker, under Article 152, this motion by the Honorable Jack Wamboka is the last resort that the people of this country, through the elected leadership, can take as a way of holding to account those that have been put in service of the nation.
Order, Honorable Wandai, you are anticipating debate.
I just want to thank you very much.
That is more than thanking the Speaker.
and appeal to my colleague members to turn out in their large numbers. We want this House on Thursday to be full to the brim, so that we can speak in one accord. We can speak in one voice in defense of the defenseless Kenyan citizens. Thank you, Honorable Speaker.
Yes, Chepkonga.
Thank you, Honorable Speaker. You know, I thought the minority leader just wanted to thank you, not to appeal to us, to do an oversight role, which is guaranteed under Article 95 of the Constitution. Mr. Speaker, we are aware about that particular provision. So there's nothing to appeal to any of us here. We will play our role when that motion is presented here, Mr. Speaker. I can assure him there's nothing to appeal to us when it's a constitutional requirement for us.
I've already cautioned him. He was touting and soliciting. Honorable members, take your seats. We'll go to order number 8 before we come back to... Let's put the question as order number 8, number 9, 10, and 11. Call out order number 9, sorry.
Number 8. Can I start with 8?
The resolution.
Yes.
Okay.
Order number 8, procedural motion, resolution to hold a Thursday morning sitting.
Majority Leader.
Pio. Honorable Speaker, I beg to move that pursuant to the provisions of Standing Order 33C, this House resolves to hold a morning sitting on Thursday, 2nd May 2024, commencing at 10 a.m. for purposes of considering priority business ahead of the long recess. Honorable Speaker, I'm sure members will note I have amended the 9:30 that was published in the order paper as agreed by the House Business Committee this morning, that we begin the sitting at 10 a.m. And Honorable Speaker, the reason for having this Thursday morning sitting, as you have ably communicated and following the notice of motion by the Honorable Wanami Wamboka, that motion is time-bound, and therefore we must dispense with it by Thursday. And considering that we are losing a sitting tomorrow afternoon, it's important that we compensate that sitting for tomorrow afternoon with a Thursday morning, and allow me to plead with all members to be available on Thursday, 9:55 a.m. for the House to be able to sit from 10 a.m., consider the business that will be on the order paper, including that motion for impeachment of a cabinet secretary that is time-bound. Therefore, Honorable Speaker, I want to ask members to be available on Thursday. It is also our last sitting day before the long recess, which is a long working recess, and therefore it will be important that we are here in time. With that, Honorable Speaker, I beg to move and request the Leader of Minority to second.
Honorable Wandai.
Sorry, just give me. Honorable Speaker, I rise to second the motion as moved by the Leader of Majority. And Honorable Speaker, really, since tomorrow is a holiday, it's a public holiday, we need to really recover the days we shall have lost tomorrow. But more importantly, Honorable Speaker, there are businesses before us that we need to dispense with. We need to dispense with certain businesses before we go on the 1-month recess. And top of the agenda is the motion by the Honorable Jack Wamboka that we need to pronounce ourselves on as a House on Thursday, the earliest possible time on Thursday, before we can adjourn for the long recess. Secondly is the IBC Amendment Bill, which is one of the NADUCO bills that are being processed by Parliament. Honorable Speaker, this morning we had a session with you under your able chairmanship, and we were able to thrash out some of the sticking issues surrounding that bill, save for basically one small issue that we shall be dealing with in the course of time between now and Thursday morning. We should be able then, therefore, to dispense with that bill on Thursday at the Committee of the Whole House, so that the Senate can be seized of it, for us to be able to have in place a working, functional IBC, Honorable Speaker, in the shortest time possible. So, Honorable Speaker, therefore, I think it is in order for us to support this motion, for us to be able to sit on Thursday in the morning. Even though we have agreed on Thursday at 10 a.m., let us try to be here as early as 9:30 a.m. so that we can deal with these issues properly, honorable members. This is a historic moment. You never get it easily. A whole house, a whole term of parliament can go without you getting an opportunity to deal with a motion such as the one presented by Honorable Jack Wambok. Thank you very much, Honorable Speaker. I second.
Honorable members, I now propose the question, which is that pursuant the provisions of Standing Order 33C, this House resolves to hold a morning sitting on Thursday, 2nd May 2024, commencing at 10 a.m. I believe you moved the motion, Order Majority Leader. You moved the motion in amended form? Yes. Commencing at 10 a.m. for purposes of considering priority business ahead of the long recess. Put your question. I put the question? Yes. Honorable members, I now put the question, which is that pursuant to the provisions of Standing Order 33C, this House resolves to hold a morning sitting on Thursday, 2nd May 2024, commencing at 10 a.m. for purposes of considering priority business ahead of the long recess. As members of that opinion say aye. Aye. Will those of the contrary opinion say nay? The ayes have it.
Order number 9, motion, report of Committee of the Whole House on the consideration of the Senate amendments to the Water Amendment